All right, I've had a lot of lawyer jokes in the last 10 minutes, you guys. My favorite was we had to boo somebody, and so we saved you for last. Like, oh, great, thanks so much. But no, seriously, I think it's hilarious that I'm speaking right now because we fully exercised our right side of our brains, and now you've eaten lunch, you've been sitting down for 2 days, and I'm last. Oh, great. And everyone's favorite joke, right? No pressure. And everyone's favorite joke when they're the last speaker is, I am the one person standing between you and the raffle table. So I will try and keep you awake. I'll try and hopefully give you a lot of tools. I know that you're going to laugh at this. Well, it's awkward if you don't laugh at it. I think you will laugh at it. I gave the title of my presentation long before I actually crafted the presentation because I'm always changing and trying to update and do things. And I really felt like, okay, I really want to focus on the top 3. And I'm like, I'll figure out what the top 3 are when I get closer to the time. And I'm like, oh no. The top 3 really are determined by you because every one of your situations are so different. And I've been speaking with so many of you here today. And for one person, the top 3 is a caregiver agreement they never knew that they should have. A Medicaid Asset Protection Trust, how to fund a vehicle. Like all of these are legal things that are going to be your top 3. It all is so unique to your situation. So today, I'm going to give you an overview of many different things and that I see in my experience that have made a difference in the life of the individual or the client that I was working with. You're going to see things on my screen that you may not hear me talking about. Most of it, I'm going to say most of it, is in your handout in front of you. However, I did add a few things just in the last hour because some things came to me that I felt like I needed to just throw up there. I am going to trust that you are going to hear and you're going to read what you uniquely need. I am going to just send it out to the universe that you will be magnetized and hear what you need. I'm going to hope that I don't overwhelm you because I know this can be an overwhelming topic when we're talking about legal things. But I think with my stories and things like that, I think we'll get some context. Does that sound like a good deal? Is that y'all right? And I promise I will not leave this room. I will not leave the conference until you feel that you have a tool or a resource or an answer to a question that's burning inside you, or I'll give you information on how you can get a hold of me later, if that's okay. Does that sound like a plan? Okay, because I know you all need to beat Salt Lake City traffic too. Okay, we don't want to be going home during rush hour. It's nuts out here. So just as an overview, because I know that it's super helpful for you to understand, why am I even speaking about this? So this is just an overview of just kind of my journey. I was born in Canada. I'm a Canadian, was raised there, my family. That's my mom. And then here, can you tell I am exactly 11 days overdue with my first child? You see that bump there? Okay. That was me last week, 25 years ago. I graduated from BYU with a history major with a minor in gerontology. Always loved the elderly. My mom actually taught me to love the elderly. We did not have a lot of money when we moved from Canada to California. It was in '89, right when that recession hit. And my dad lost his job. My mom had to work for the first time in her life, and she cleaned the homes of elderly in my community. And I cleaned their homes during the summertime while she did foreign exchange students. So I was a homemaker, house cleaner for several very important people in my life. And we may have an opportunity to introduce you to one of them later on. So always loved the elderly, minored in gerontology, and this is me on my first day of law school in 2005. I drove the kids to school, dropped them off. My mom actually stayed with my youngest. She's always been my biggest supporter. And then I would go to school all day, and I'd pick them up on the way home and bring them home. And we would get them to bed by 7:30. I'd do homework until 11:30, get up at 4:35, do homework until 6:30 in the morning, and then do all the piano and the and do it all over again. So this is graduated from BYU in '99. We adopted 2 children from Haiti in 2003. This is the day I took the bar. That's my welcome home mom sign. Do you see it in the background? So that's the day I took the bar. Had my little Michael that last semester of law school. Worked for the State Office of Education for those first 7-8 years out of law school. Started working for an estate planning law firm because I was delivering Meals on Wheels for about 10 years because I wanted a service opportunity to do with my young kids. And so I'd bring them with me, and I was delivering a meal to somebody, and they were going through some tough times. And I remember handing the meal, and I'm like, I can do so much more. I'm a lawyer. I'm like, what am I doing? I'm delivering meals, and I should be helping them because I have a background, I have a love, and I have the skills. And so I joined an estate planning law firm and was trained by them for about 2 to 3 years. And then, along with every entrepreneur we all have in common, we are all profoundly rebellious people. And I just couldn't stand it anymore, guys. I just had to do it my way. I had to do estate planning. And you'll see that the way I do estate planning is very different from a traditional estate planning attorney. I am very transformational, not transactional. I like using estate planning to impact family relationships, not just check a box. Okay, so I leverage these documents that are truly at the crossroads of life and death and generations and use them to leverage conversations. That is a presentation. That is for another time because I told you legal priorities, not today, not these crossroads conversations that we can really emphasize and we can discuss. So I'm going to be focusing more on a little bit more nutsy and boltsy today, but still I can't help. I'm going to slip in a little bit of purpose in there too. All right. Oh, there's my legal team. Oh, there's my team. You guys all may have seen Anna yesterday. Deb's here in the back. She's cheering me on. And then we've got another attorney, Leslie. She's a U of U law professor. Julie is my family care. Kim. So anyway, this is my team. Love them so much. We do great things for our clients. And then here's other attorneys in the Valley that I work with, I co-counsel with, because I do not believe in being an echo chamber. Sometimes I have to reach out, so just to let you know, I have some other peeps. Kind of my background, how I got into estate planning. We had all these kids. I kind of gave you an overview. One of them had an undiagnosed special need. I had 5 kids under the age of 6. I was going crazy. We never had any time to ourselves. I needed all of these estate caregiving resources, right, for me. Just, you guys all remember the beginning, right, when you had all the kids at home. So, of course, I had an estate plan at the age of 27, because I was like, if something happens to me, I can barely survive. Something needs to happen with them. So I had a trust made that declared a guardian and had my professor at the law school review it and pointed out all sorts of problems, concerns. And so that really has rooted my passion of, hey, you know what? You may have an estate plan. You may think it's doing great. Just be open to having somebody take a look and just kind of give you a third eye on what might be happening there and just talk you through it. So. And then over here we have, these are my husband's grandparents, his father's mother and his mother's father. And I was a caregiver for Grandma Phipps. I was the one who, fortunately, she was always in a care facility where I wasn't there for the 24-hour aspect of caregiving, but I was the one who took her to the store, and I'm the one that, filled her pill bottles, and I'm the one who, took her to get her glasses done. I was that weekly caregiver, and I had a really important experience with her the last month of her life where she wasn't receiving the care and the advocacy that she really deserved from her healthcare advocate, from her healthcare agent. And she had asked me to be her agent for the last 5 years of her life, but I kept saying no because I was the granddaughter-in-law. And that experience with that final year of her, final month of her life, and the lack of support and the being told that she was faking it, not being taken to the doctor. I got her on hospice, her being taken off of hospice, her being denied pain management, med management, transport, help in the morning and in the evenings to get in and out of bed. She was not she wasn't allowed by her healthcare agent to have that escalated care. And we actually got Meg involved with an ombudsman to try and get that support. That taught me just to really make sure when I'm educating the community to make sure that you are aware and are very careful about who you're choosing to put in these positions of advocacy in your life. Because once you lose capacity, you will not be able to change those without a court, okay? So it's so important to not feel like you owe anyone any role in your care in your later years. You owe it to nobody. Nobody deserves to be your advocate if they are gaslighting you, if they're making you feel crazy, if they're not being supportive, if they're not being somebody that you feel like you are being empowered by. Does that make sense? So that's my experience with Grandpa. He bought a house in Alabama when he was 93 and didn't put it in his trust. And he didn't tell anyone that he had done this and not put it in his trust. So we ended up in out-of-state probate in Alabama during COVID. Not a fun thing for his granddaughter who he was holding the mortgage for. So that's just another thing. We are going to start there because that's the number one thing I can do to save your family a lot of headache, and for you a lot of headache, because these are things that need to be taken care of before you lose capacity. Is we need to make sure that you're gathering all your assets, you're putting them, making an organized list, and you're making sure that you have beneficiary designations, or that they're in, if you have a trust, that they're in the trust. Okay, so we're going to start there. That's the one thing that I find when I'm speaking to groups that they have a lot of misunderstandings about. So we're going to start from that foundational level. Does that sound okay? I'll write that. Okay. So just my name, Angel Advocates. Who's the angel of, I believe my clients are, that they are angels in the lives of their beneficiaries. They're angels in the lives of those that they will leave behind one day. And I believe that you're, that I kind of had this little daydream that we're kind of like little, strumming our harps, and looking down saying, oh, I left a great estate plan. Look at them. Like, they've got great assets going on there. They're protected. Everything's going really well. Or the alternative is like, man, I totally blew my estate planning, and look, they're all fighting down there, and I really thought that I did them I thought they were all going to love each other, but now they hate each other and they're fighting. I think we're going to know about it. That's just in my little daydream. That's what I think. So I believe you're an angel. I believe they're an angel in your life. You want to, that you love these charities or these beneficiaries. And of course, I hope to be an angel in your life. So we're angel advocates. So here we go. All right, so here in Angel Advocates, I emphasize that there are 5 advocates that you need to have in your life, and you have an ability to choose those advocates. And the important thing is to choose them before you cannot choose them, and to choose them before they are chosen for you, because there is a default for these situations. So today we're going to emphasize these first 3. I do have other 2, but we'll see if we can get to them. So we're going to hop in. Your last will and testament is your final teaching. What do you want it to say? So your asset advocate will be the one who speaks for you and directs your assets when you can't speak anymore. So they ensure your assets are there to provide for your financial needs when you can't manage things anymore, and they will be the ones who will work with your beneficiaries on your behalf after you pass away. So keep that in mind. The key word here is that you is choose. If you don't choose, they will be chosen for you. And especially for those of you who are caring for a loved one who maybe have experiencing diminished capacity, these are important conversations to have before they lose capacity. Fortunately, and also dangerously, the capacity to do an estate plan is one of the lowest levels of capacity, okay? So you need to be able to identify the objects of your affection. Does that sound like a legal term? Yeah, okay, the objects of your affection. So you need to know who your kids are, right? Or your sister, your brother, or you need to know, who the natural inheritor would be. Because if you don't want it to go to them, you got to know that you don't want it to go to them. And if you do want it to go to them, you need to be able to know who they are, right? So you still need to be able to recognize the natural objects of your affection. You need to know what your assets are. You need to have an idea of what your assets are. That doesn't mean you need to have account numbers memorized. You don't need to have, all right, so the level of capacity. So you've got to be able to identify your assets, and you need to be able to formulate a plan. So if your loved one is still able to know who you are, who their children are, that they have a house, they have some bank accounts, they have they have some IRAs, have about X amount of dollars, and they know they can formulate a plan of what they want, we can actually do an estate plan. Now, if there is some sensitivity about capacity, either they want to do something really wild and crazy, I would require a capacity evaluation. Okay, I'm not going to throw my license into vulnerability with people coming and being mad at me for estate planning that I've done. Even though they did have capacity, we would have a capacity evaluation done so that a medical professional would have verified that capacity. Okay?
So this is a silly question.
Yes,
so
please.
If one parent, and I mean this is just
strictly hypothetical.
Yeah. Hypothetical. Like if they're like, I'm really mad at my child, so I'm going to take them out of the will, and they come to you and they're like, yes, this is Ben, and he's no longer in the will, but we're not going to tell him until I'm gone. What would you do in that case?
Okay, so that's a great question, because that's actually cuts at the heart of how differently I practice estate planning. In fact, that was one of the major concerns I had that kind of put me on a crusade, because I was attending it was a Mountain Land Association of Governments Caregiver Coalition meeting with another estate planning attorney who was present in the meeting, and she did a presentation there where she was joking about how she disinherits and reinherits children on a yearly basis for some of her clients. And I just about died, because that is absolutely, to me, that is weaponizing estate planning. And it makes me livid. Okay, so, sorry, I'm like, let me look in the camera. It makes me livid. I think that is a gross abuse of power by an estate planning attorney. Because I know you loved that child at one time. I know you did. And I know that child has a whole system of things that have happened to them, of environment, of social, of birth order, of who knows what, of potentially physical things that have contributed to where that relationship is now. So in that situation, it's usually at least an hour to 2 hours before I will move forward with a disinheritance or an alternative inheritance pattern. Of course, I have to be confident that they have capacity, like you say, but we will explore everything, including, I remember one individual who came to me, and he had been attending some of my presentations at a place where I present regularly, and he was so grumpy, and I just was like, I don't even know if I want to work with this guy, because he's going to call me up one day, he's going to want me to help him. And he did end up calling me, and he wanted me to disinherit his daughter. And after talking with him it was about 30 minutes, 40 minutes, I finally asked, tell me about the relationship between her and your son. And he said, oh, they get along great. They're great. And I'm like, so the one person, the one family member you're leaving her with when you pass away, the one person, you want to blow up that relationship so that she has no one after you're gone. And do you really want to do that? And he was like, oh, he had never thought of it that way. So in this situation, we had done something creative, which is an alternative to disinheritance, where we look at the funding process, which we'll talk about in just a minute. We'll look at funding, and we'll say, you know what, in this situation, he had a hefty life insurance policy. Well, guess what? We left it all to the son, completely out of the trust, okay? We did not, so that the trust is divided equally, but we have this little side life insurance policy that did benefit the son, who was, yes, higher functioning. Yes, he didn't have an out-of-child out of wedlock child. Yes, he didn't have a drug addiction. Yeah, you know what I mean? Yes, okay, there were reasons why he didn't want his daughter to inherit a large sum of money, but you can do it without blowing up the relationship. She also, often when people have, when they have addiction issues earlier in life, their brains work differently towards the end of life and midlife. She really, really highly valued personal property. It was like a big deal to her, like the couch. Like she would say, this is why her dad didn't like her, because she would come over and say, when you're dead, can I have the couch? And he would be like, you're out of the will. Like, you're out of the. So, honestly, we left her the personal property. I mean, she's going to be thrilled. So anyway, that's some things that we can, explore. All right, so what I wanted to say here is that what do you want to say? Not just what do you want to say, but who do you want to have say it? Okay, because this person will be representing you after you're gone. That their attitude, their love for your beneficiaries, their ability to manage your assets will be representative of you. So you just want to be thoughtful about who you put in that position. So here I'm going to just go through that. Whenever you hear the word estate, it actually doesn't necessarily mean everything that you might own. It only includes those things that did not pass to a surviving joint owner. So this is super important. So an estate is not just everything you own. So the first thing that gets pulled out of your final estate is your jointly owned assets. They go to the surviving joint owner. So we're talking about bank accounts, right? Or a home, like if you have a joint tenant with right of survivorship, that is not going to go, is not governed by a will, it's not governed by a trust, goes to the surviving joint owner, okay? So that asset is out, okay? Goes to the surviving joint owner. Okay, the next asset with the beneficiary designations go to the beneficiary. So any account, any life insurance policy, anything that has a beneficiary designation, it's not governed by your will, it's not governed by your trust, okay? So we want to be really, really clear about that. And then finally, anything left is your probate estate. That passes pursuant to your will if you have one, or state law if you don't. Assets are not immediately available, and loved ones must go to probate to get access. So wills do not avoid probate. Just want to make sure everyone knows that. Wills are the love letter to the judge. Okay? All it is, dear judge, this is what I'd like to have happen when I'm gone, instead of the default. Okay? So, but it never gets to the probate court when there's a joint tenancy or when there's a beneficiary designation. Is that clear? Does everyone understand how that works? Does that make sense? Okay. I'm checking for understanding here.
If there's something in a trust, does that still go to probate?
Okay, so that's the next one. Okay, here we go. A trust is a will substitute. Okay, except that it doesn't go through the probate court. So remember how we're at the probate court when when life insurance proceeds are paid directly to a beneficiary. You end up at the probate court if they go to an underage beneficiary. This is the same place, so the probate court. This means that even if you have a will, your family still has to go through probate court, and if someone leaves no will, then we still have to go to the probate court. So everything going through probate court requires a legal notice to all parties involved, even if a family member is disinherited. And it's while it's absolutely critical that you have a will, it's definitely not the only piece of your estate plan. So now we're going to be heading into trust land. A trust is a will substitute, except that it doesn't go through probate court. So the first type of trust that we're talking about here is a revocable trust, and that will help us avoid probate court. Let's see. So here is the difference. Okay, so that you're talking about. Your share of a jointly owned assets are put into your trust, okay? So instead of a joint tenant with right of survivorship house, we put it in the name of the trust, okay? So now it's out of probate court, okay? When both of you are gone, right? Okay, because it goes to the survivor when only one is gone. So you put your house in the trust, now you don't have to worry about probate court. That means that a trust just means somebody can sign and sell that home on your behalf under the terms of your trust, okay? Beneficiary designations are updated to your trust. So instead of having a bank account that has a pay-on-death beneficiary, you put it in the name of the trust, and now it's distributed according to the terms of the trust, okay? And also the trustee can operate it in case of your incapacity. A trust is a really great way to manage incapacity. And I am seeing furrowed brows, and I'm seeing the gears churning. Is there any questions that of what I'm saying? Because I know I'm using a lot of legal jargon here.
So are there various different kinds of trust that you can start? Can you give us just
A smattering? Yes, absolutely. Maybe some of you are familiar with VA benefits. There's a kind of trust that you can put your home into to qualify for VA benefits. There's something called a Medicaid Asset Protection Trust, which is another type of irrevocable trust. Irrevocable means you can't change it after you pass, or after you create it, okay? A Medicaid Asset Protection Trust, if you do it 5 years before you need Medicaid benefits, they don't count that assets in that trust as disqualifying assets. Okay, so that means they don't collect against them after you pass away, because they'll put a lien on your house and pay back Medicaid, but if it's in that Medicaid Asset Protection Trust, they won't do that. So that's another kind of trust. Another kind is a domestic asset protection trust. That just is a type of trust that allows you to have asset protection. So yeah, there's lots of other kinds of trusts. A foundational planning, though, don't get too far in the weeds, okay? Foundational is revocable. And that's just to make sure that your wishes are being followed for your assets and that you have an incapacity plan that follows all of them. The financial institutions just salivate over a power of attorney that they get to say no to. It's like, which, for good reason. There's a lot of things going on in the world. There's a lot of people that are taking advantage of our elderly and our incapacitated adults. And it's very easy to take a power of attorney and slip it under your nose, and you think you're signing, a thank you card, and all of a sudden they're selling your house. Like, it's that easy with a power of attorney. It's pretty scary. But with a trust, if that asset is in the trust, it's a much more formal process of creating the trust, and they are able to talk with that successor trustee. It's just a much smoother way of handling incapacity. Yeah, so go ahead.
Not a trust question. Is there a minimum amount of value for your assets that trigger going to probate?
Yes, there is a small estate affidavit that you can have signed. So you say, let's see, it's like under 100,000. So if you have assets in under 100,000, but it can't be real property. So you can't have a deed to like a sliver of land. And
Cars, bank accounts, things like that.
cars you can take care of outside of probate. Yeah, so that's a good one. And then bank accounts really depends on the bank, because banks like to be super grumpy. I know certain banks in particular, it doesn't matter what the size is, they will require you to go to probate. Yeah, they're terrible. Yeah, no, it depends on the bank. I'm telling you, I did a lot of research. We actually called all the major banks here in Utah just to get a sense of how they treated many of these legal questions and what they would do in the case of an incapacity or a passing. And I'm telling you, there are, I won't say this because this will be recorded and they'll come and get me, I'm telling you, there are certain banks you want to run from, because you cannot even get somebody on the phone, let alone somebody to talk to. There's one particular bank that the moment your loved one passes away, even if your accounts are in a trust, they will freeze your account. Okay, so you're in a trust, but the moment they pick up that your spouse has passed away, your assets are frozen. It happened actually to one of my clients. So anyway.
So, question. So let's say you have your trust and everything in place. People pass away, there's no one left. Should we go back to the person who wrote the trust? Like, I've heard that, hey, there are going to be taxes that are coming in. Like, be careful if you're the executor or executrix, because you're going to have bills that are going to come in. So how does that all start to get rolling once everybody
Ooh, okay, that's a really good question, and we could do an entire presentation on trust administration, and I know that that's not in line with my theme today. So it would probably be a good one for us to talk about separately, but just know that I would recommend that you do speak to legal counsel when the first trustee passes away, because there are certain deadlines that are going to start clicking. Especially if you have an estate tax issue, you want to make sure you're filing to capture your estate tax exemption for that first spouse. So just know it's always wise to talk with a legal representative. It does not have to be the person that drafted your trust. And so okay, we'll talk though. So when it's in a trust, all your trust assets are immediately available for your loved ones. There's no court required. So that's another convenience as well. So just to kind of recap, there is no probate court for all of your assets in this cute little red wagon. So let's pretend they're all in there. And you put them into your trust like the toys in this red wagon. So just imagine when you're a little kid, you had your toys, and you have cleaned them all up, and they are in your wagon. You wrote your instructions on what you want to have happen. You tied it to the handle, and all you got to do is just pass that handle on to the successor trustee, and they're able to just keep walking. Does that make sense? Just keep going. If you don't fund your trust, your assets go through probate, and it's kind of like throwing your toys all around the yard, and everyone's trying to find out where your toys are, and they don't know what to do with them, and then the court has to gather them together, okay? So your personal representative has to gather them all together and then take care of those. All right. So all trust assets avoid probate court and are available immediately to support your loved ones. So just a much better scenario. Okay, so here's kind of an overview. I'm going to take this if I can. So,
Can I ask you a question?
Yes, go
When
ahead.
you say if you don't fund your trust, what does that mean?
Oh, that's such a good question. I planted her there. Okay, so funding, this is kind of probably the most complex, and I will educate a client at the beginning, middle, and end, and they'll still be like, what's funding? So funding, think of it in terms of attaching your asset to the trust. Okay, so like picking up the toy off the ground, putting it in the wagon. Okay, so the difference is that normally we use beneficiary designations, like a pay-on-death beneficiary. When I pass away, the person, these are the people who I want to have inherit this asset, this bank account. Instead of listing a beneficiary designation, which does not tie them to the trust, because can you imagine if that person predeceases, who's going to get their portion? Well, it could be their children. Well, you may not want their children to receive that bank account. There's a lot of different scenarios, and I have other things that we could talk about. And I have a webinar online that explains this in further depth using a story. So it follows a storyline. It's a little bit easier to follow. I'm just kind of cutting to the meat of it today. But when you fund your trust, you're attaching the asset to the trust by changing the beneficiary designation. But instead of, well, sometimes we have it be the trust, but most often we actually change the owner of that asset to the trust. Okay? Now, as a revocable trust, you're still the trustee. You're still in charge of it. You can buy, sell, blah, 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 all of it. You can benefit from it, all of those things, but your power comes as the trustee of that asset. And so that it's just gathering everything and splitting up ownership versus power to administer that asset. The nice thing too is that you can change the terms of that trust, so you can change your successor trustees, you can change the people that you want, you can change your how you want that asset divided up, because as you age, you may find that all your children turn into billionaires and they need no money. And you're going to now leave it all to Linden Legacy, because they're a wonderful foundation. And they accept funding from anyone else. So you may find that in one trip to your attorney, you're saying, you know what, I'd like to change my beneficiaries. So then it impacts all of your assets, right? Because they're all under one umbrella, and one change changed all, took care of all of them.
So I do have the trust, and the name, for my for my bank, it actually comes like the trust of,
Mhm.
so is that,
Yeah,
that's been funded?
Yes, that's been funded. So when you receive mail from them and it has,
Yes.
it's under, then it says the trustee of the blah, blah, blah living trust or whatever. Yeah. Yeah, that's a good, in fact, we require our clients to send us all of their statements so that we verify funding for them because so many times people will overlook that.
Should I put my bank account in first? Because for the bank account, I have the beneficiaries designated. And is there any advantage of putting it in first?
Okay, so the question was, is there any advantage to putting the bank accounts into the name of the trust? So now I find a lot in not communities, but communities like this, that they'll add a child onto their bank account to make it convenient to administer their assets, pay bills and things like that. That is not recommended because that asset actually shows up as their asset. So if they hit somebody in a crosswalk, it attaches to your asset, okay? And also, another problem is that when you do that, they're a joint owner of it, okay? They're a joint owner, guys. So this is what happened to a loved one of mine. She was told by her power of attorney, let's add me to your bank accounts. She went along with it, and she couldn't get him off. You cannot remove somebody who's a joint owner from your account. So you have lost control of your assets there, right? So it's just, I don't recommend it. I think it strains family relationships, especially when that individual, her son, then added his wife to the bank account, who she didn't get along with. So can you imagine, like, it just creates a vulnerable domino effect of impact. So what I recommend, and this gets to the answer to your question, is if you put it in the name of the trust, so we're now, the bank account is in the name of the trust, so it's the so-and-so living trustee, blah, blah, blah. If you do that, then the trust successor provisions and incapacity provisions govern that account. So it's a very safe way of having incapacity planning. Okay, so instead of having a power of attorney, them having to go around with a power of attorney, or having them on the account with you, the bank asks for a certification of trust, and that certification of trust is a document, it's about like a one-page document, that's an overview of your trust that lists your successor trustees, gives the name of them, so that they know that if something happens to you, they can talk to these people. Now, they have to prove that you've either passed away or you're incapacitated, or you can choose to spring that and bring them up as trustees. All we do is change that certification of trust, and any attorney can do that for you. So it gives you the flexibility of having a backup in case something happens to you while you still staying in control. And that's what I really want. I really want my clients to feel like they are in control as long as they're able to be in control. Okay? Okay. Does that answer your question, do you feel? Okay. Okay, thanks, Peter. Okay, this is I couldn't stop. I kept adding numbers because I'm like, I have to tell them one more thing. So here's some things. Is there anything up here that you would like me to touch on? I can't even believe we only just have a few minutes left and I didn't get to. Go ahead.
You have family outside the state. Is this just pertain to Utah, or this is applicable to outside of Utah?
That's a great question. This is, the things that I've talked about today is general trust law. So, applies to other states. I haven't gone into anything really state specific today, but it is important that if you have moved here from another state to update your documents, if this is where you're domiciled, I would recommend you doing that. And as well, literally every 3 to 5 years, it's good to take a look at your trust. I actually have clients in membership where we look at it every year. And you would be surprised at probably half the time they're making changes. Because when you start being familiar with your documents to the point that you know what's in there, then you're like, oh, that doesn't feel so good anymore. And then it also allows them to get questions answered. Because a lot of times things will come up in their lives that they didn't anticipate when they were drafting the documents, and they're not sure if their documents work in that situation. So I get to either say, why, yes, I anticipated that, and look at this article, and that's how it addresses it. And then they have peace again, right? They didn't have to do anything. Or they take a look at it, and they're like, oh, yeah, we've got to change. We got to make an update there. I do, of course, try to draft the documents to anticipate the general things, which is why my trusts are larger than most. But I'd rather pack the kitchen sink, you know what I mean, than to wish I had something that it didn't get put in there. So something I just want to really quickly, of course, complete inventory of assets before your level loses capacity. You'd hate to wonder if you have to go chasing down assets. I'm sure many of you probably know about situations where they spend a year trying to find all the assets in the estate. Check your deed, beneficiary designations. Also make sure you list a Social Security payee. Okay, that's super important because they do not take powers of attorney. Social Security has to appoint a payee if an individual can no longer accept or direct the payment of their Social Security. Do not hold joint accounts with anyone but a spouse, so that I've talked about that with you guys. Sign a power of attorney. Of course, you know how important that is. Will, we do, of course, a pour-over will. You want to make sure you have a pour-over will into your trust. I would assume that all of you, if anyone who has a trust has one of those. That's in case something inadvertently gets left outside of the trust, in the yard, right? Outside of the wagon. Things get forgotten about. You want to pick up and scoop that toy into the wagon, and that's done through a pour-over will. You have to go to probate still, but at least your trust will govern that asset. Caregiver agreements. This came up when I was talking with somebody. Just want to make sure you know that if you have a loved one, a child, somebody providing care for your loved one, or for you eventually, put them on a caregiver agreement, and then the money that you pay them, you can actually pay them and it won't count against your Medicaid qualification. But it has to be done proactively. So you can't be like, geez, my grandson's been mowing the lawn for me for the last, 5 years, and I've been paying him, $30 a week, and all of that money could have been used for spend down. Anyway, there's other things. Maybe your daughter will, stays the night with you 4 nights a week. You could pay them at a going rate, and it won't count for Medicaid spend down. But it has to be done proactively. Okay, so you can't go retro. So I got to plant that seed for all of you guys to have like a little bell in your head. Okay, MAPTs, we did talk about that, Medicaid Asset Protection Trust. This is really helpful for my clients who are land rich but cash poor. And so they have a home, maybe they inherited their mother's house, but they have a limited monthly income. If we just put those houses into a Medicaid Asset Protection Trust, wrap them up, put a bow on it, and then 5 years later, they can qualify for Medicaid without having to sell those assets or have those assets claimed. Don't sell any property or advance an inheritance. It's not that you don't, but don't do it without talking to somebody, okay? And also just know that you can give up to $18,000 per year per person, and you don't have to pay, you don't have to have a gift tax return filed. That's a great way to spread the love around. And that's, if you have a spouse, and you could do $36,000 on December 31st and $36,000 on January 1st, you can do a lot of blessing of people's lives relatively quickly and without issues there. But be careful, because if you were to sell property or advance inheritance, it could impact you tax-wise. So just don't be willy-nilly about doing that. I just hear people saying to me, and they'll just haphazardly say, yeah, I'm going to do this, but then they end up needing to qualify for Medicaid. I know one person that was like, oh, I'm just going to give away I'll just advance everyone their inheritance, and then I'll go on Medicaid. No, you can't do that, because then you're in penalty. Any money that you give, you have to wait that amount of time after you qualify, and you have to pay out of pocket. Okay, so the government's not stupid, guys, okay? So don't be stupid. Don't think you're getting away with something. Express your values, feelings, and intent. Once again, with our question about disinheritance, there's a lot of things that we can do to do creative estate planning when we give it context for the purposes and really why you chose to do that. I'm just going to share this with you. These are from actual estate plans that I've done. These were the insert boxes, the text boxes of some of these people who shared. This top one here was we inserted at the top of a living will. Because that living will, that's a document that's pretty depressing. You know, it's going to be a pretty bad day, the day that your loved ones are reading that living will. So can you imagine how different that would read if they're reading, okay, I want you to let me go. I need you to, pull the plug, but it had an expression of love. So think about personalizing your documents. Here's a gentleman who had a whole list of charities that he was giving to, and we incorporated a sentence about why he was giving to those charities. So it gave context to his loved ones and really spoke and created a document that was truly representative of his values and his vision. And then this last one here, I asked my clients, give me 4 reasons or 4 things, expressions of love or advice for your loved ones with what you would like them to know when it comes to their asset or when they're with their inheritance. And I just love how it's never pay interest to a credit card company. Get as much formal education as possible without going into debt. He just was very, very, very practical, but expressions of love. Well, I wasn't trying to be too prescriptive. I tried to avoid going around making having people be really prescriptive with their beneficiaries, unless in certain situations. But it's something really beautiful to see the purpose behind it. I know that we are out of time, so. Once again, so many things that we could do. I just want to show you this quick picture here. This is this is me in high school. Actually, this is out of college. I was in college here. I went back to visit Mr. Smith after high school. I cleaned his house. And so he was a dear, dear friend of mine in my teenage years. And I just want to show that when I did come back, his wife that I had helped care for, she had passed away, and I met his new girlfriend. Okay, so this is where the importance of potential exploitation comes in. I just want you to know that please find someone who is not a beneficiary, is not a family member, that you trust, that you would respect, and somebody that you ask to be your potential exploitation advocate, that if something happens where your attorney is concerned that you are being exploited, that you do have capacity, but that you now want to disinherit everyone and give it all to your new girlfriend who is 40 years younger than you, which happens, guys, it happens. You're lonely, your kids aren't visiting you anymore, and all of a sudden you want to disinherit everyone and you want to have your wonderful caregiver who, please have somebody, make a deal with somebody to slap you, to pour water on your head, to, whatever it is. But as an attorney, I actually have all my clients name a potential exploitation advocate that I'm allowed to call if my spidey senses go off. And I'm like, because I've got attorney-client privilege. I can't break that without permission. So I just had to throw that in there because we are talking about incapacity here. So.
When we did our will and trust, we also did it regarding our 2 girls, and if something should happen to them, that the money would go into a trust with our other daughter, not for her husband, because they'd be married again. Would all that money go to her children, and we didn't want any of that. They didn't really like it, but we were like, it's in your best interest.
Yeah, and I actually I have clauses that I'll use as well that are divorce clauses or the prenuptial agreement clauses. I have a type of trust that I'll put called a general needs. I call it a general needs trust, where the inheritance goes into a general needs trust so that if they were to pass away before you do, then after you do, but before they receive the full amount, that it flows to them separately, because inheritance is considered a separate marital asset, so it's not supposed to count in divorce, but if they commingle, then it's lost, right? The protection is lost. So yeah, there's lots of conversation when it comes to that, and we can talk all about mandatory prenuptial agreements for the second spouse who's surviving, because honestly, the same thing could happen if a spouse passes away. I tell you, a lot of the conflict that comes with estate planning comes from second marriages. So there's that's a whole presentation we could do just on how to avoid conflict with second marriages. But anyway, as you can see, there's a lot of things I skipped. I know that I think we had a lot of really great pertinent questions answered today. And we can, I of course am willing to stay after if you want to discuss or answer any other questions. It's up to what's best in interest for you and your time. So thank you so much.
Thank you.